Welcome to the Bar Exam Toolbox podcast. Today, as part of our Listen and Learn series, we're going to be discussing professional responsibility and specifically exceptions to confidentiality. Your Bar Exam Toolbox hosts are Alison Monahan and Lee Burgess. That's me. We're here to demystify the bar exam experience so you can study effectively, stay sane, and hopefully pass and move on with your life. We're the co-creators of the Law School Toolbox, the Bar Exam Toolbox, and the career-related website Career Dicta. Alison also runs the Girls Guide to Law School. If you enjoy the show, please leave a review on your favorite listening app and check out our sister podcast, the Law School Toolbox podcast. If you have any questions, don't hesitate to reach out to us. You can reach us via the contact form on barexamtoolbox.com, and we'd love to hear from you. And with that, let's get started. Hello, and welcome back to the Listen and Learn series from the Bar Exam Toolbox podcast. Today, we are going to talk about exceptions to the rule on confidentiality. This issue comes up often in bar essays addressing professional responsibility. The rule itself is not difficult to understand, but the exceptions to the rule can be tricky depending on the jurisdiction you are discussing. So let's start with the applicable rules. I'm going to start with the California rule for a change, since that rule is much simpler than the ABA version. In California, the rule on confidentiality states, "A lawyer shall not reveal protected information unless the client provides informed consent or if the lawyer reasonably believes the disclosure is necessary to prevent a criminal act the lawyer reasonably believes is likely to result in death or substantial bodily harm to an individual." That's right, just one available exception in California: the threat of death or substantial injury to an individual. But that's not all you should know about the California rule. When faced with such a scenario, a California lawyer must try to convince the client not to commit the act. If a California lawyer decides to disclose this information, the lawyer must inform the client of that fact. But here's the most interesting part of the obligations owed in California. If the attorney decides not to share this information with the relevant parties or authorities, they will suffer no consequences under the rule. In contrast, the ABA model rule on confidentiality provides, "A lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent. The disclosure is impliedly authorized in order to carry out the representation or the disclosure is permitted. A lawyer may reveal information relating to the representation to the extent the lawyer reasonably believes it is necessary. 1. To prevent reasonably certain death or substantial bodily harm. 2. To prevent the client from committing a crime or fraud reasonably certain to result in substantial injury to the financial interests or property of another, and in which the client has used the lawyer's services, or to mitigate the injury that may result. 3. To secure legal advice about the lawyer's compliance with the rules. This may include advice needed to establish a claim or defense on behalf of the lawyer in a controversy between the lawyer and the client, or to consult on the impact of the lawyer changing employment, or 4. To comply with other law or a court order." As you can tell from these summarized versions of the actual rules, there are many more options available to a lawyer in a jurisdiction using the ABA rules than to a lawyer in California. There's a lot you can do with these rules depending on the facts you are given. So let's consider how to use these rules in a bar essay. The following hypo is adapted from a California bar question from February 2022. Dan is facing trial for the murder of Victor. Dan entered into a valid retainer agreement with attorney Anita for her to represent him. Anita met with Dan to discuss Dan's defense. In their interview, Dan claimed he had spent the entire evening when the murder occurred with his father, Frank. The next day, Anita sent an email to Dan expressing her concern that his alibi was weak. Dan replied to the email and admitted that he had lied about his alibi, but denied that he killed Victor. At some point, Dan changes lawyers. The prosecutor calls Anita to testify about Dan's statement that he was with Frank on the night of the murder. Since we are focusing on confidentiality, we will not discuss the glaring question of whether Anita can be called as a witness against her client. That could be a subject for another time. The question tells you that Anita and Dan entered into a valid retainer agreement. So whether they were in a valid lawyer-client relationship is off the table. Don't spend a lot of time talking about it. The only reason you might raise it is because Anita no longer represents Dan. But that is not really important because when they had the conversation, she was representing Dan and the protections applied. Because the conversation happened within the context of the lawyer-client relationship, the obligation to keep that information applies because the privilege belongs to Dan, not to Anita. She can say nothing without Dan's consent, as both versions of the rule provide. This includes the interview as well as the email exchange when Anita questioned the strength of Dan's alibi. These are protected communications, and unless shared by the client, Dan, with someone outside that relationship, the communications remain confidential. Anita is therefore only allowed to reveal this information if one of the exceptions applies. She would be out of luck in California because this is old information, and the weak alibi does not pose a current risk of death or great bodily injury to an individual. Under the ABA, the exceptions also don't seem to be available here because, again, the information is in the past and not about a future threat. If the facts said something about Dan planning to testify and embellish, you might discuss whether Anita might be able to disclose the information to prevent the crime of perjury, but that won't be successful because the threat of harm has to be to another individual, not the client. Finally, being called to testify, even under a subpoena, is not the equivalent of a court order, so that exception will also not be available to allow Anita to reveal this information using the ABA exceptions. Let's now consider another portion of the same February 2022 fact pattern. Anita visited Dan's apartment and spoke with Dan's roommate, Ben, who said that Dan confided in him that he had killed Victor. Is the information provided by Ben to Anita the type of information that is protected by the attorney-client privilege? The answer is no. Ben is not Dan, even though he was sharing information Dan told him in confidence. The only information protected by both the ABA and California rules are communications between the lawyer and the client, and possibly disclosures authorized to carry out the representation. What this later portion refers to are people like paralegals or secretaries in the lawyer's office, or outside investigators hired by the lawyer to obtain information. Those communications are undertaken to carry out the representation. There is no evidence in the fact pattern provided that Ben falls into any of those categories, so his communication with Anita does not get the protection of the attorney-client privilege and the duty of confidentiality. Let's consider one more example from another California bar question given July 2016. During the course of Len's representation of ABC Corp., an employee of ABC informs Len that he has filed false reports with the State Environmental Protection Agency regarding the disposal of non-hazardous waste, and that he is planning to file another false report next month. Filing a false report makes a person and his or her employer liable for a substantial civil fine. Len does not take any action with respect to impending filings of the false report. What ethical violations, if any, has Len committed? This particular fact pattern raises some different issues than the other two we already considered. Under the ABA rules, you might argue that Len violated his ethical duties by not reporting the employee to the state EPA under the exception that allows disclosures for crimes or fraud committed by the client. The employee likely makes ABC Corp. Liable for the substantial financial consequences that could be imposed for filing the false reports. However, the writer will also have to consider whether this exception is even applicable, since the facts do not suggest Len's services were used to file the false reports. The only way this disclosure might be permitted in California would be to argue that the dumping of the waste poses a significant risk to the health of people living around the dumping site. This theory would also be available under the APA rules. However, given the fact the waste is non-hazardous, the level of danger posed might not be viewed as significant. It is a potential argument the writer should at least raise. And that's all we have for you today. We hope you found these hypos to be helpful examples of how to work through exceptions to confidentiality questions. If you enjoyed this episode of the Bar Exam Toolbox podcast, please take a second to leave a review and rating on your favorite listening app. We really appreciate it, and be sure to subscribe so you don't miss anything. If you have any questions or comments, please don't hesitate to reach out to Lee or Allison at lee@barexamtoolbox.com or allison@barexamtoolbox.com, or you can always contact us via our website contact form at barexamtoolbox.com. Thanks for listening, and we'll talk soon.